What's up, guys? Hope you're doing well. We've
What's
got to
up,
jump right into
guys?
live court. Damn it.
Hope you're doing well.
We've
What's
got to
up,
jump right into
guys?
live court. Damn it. I fixed it. Okay. Seriously though, we have to jump right into live court because there is a good case going on right now and I don't want to miss any more of it. So let's get jumping into it. We will talk in a minute. We are going to Thurston. We've got a TPO. Put your ready for business caps on. Okay, give me 1 second.
You filed some of this already with court, did you not?
Suffering in silence. I'm here to
Go forward.
yes, I'm here to come and ask for permanent restraining order against the respondent. I've been suffering in silence, and I'm fear for my life. Respondent has been annoying me, harassing me, tormenting me, making fun of my accent, and the list just go on. Sometimes I have to go inside to avoid that. When I'm outside, she come out several times. When I want to mow my lawn, she will come out and try to mow my lawn. I have to go inside. She's trying to start something. To start with, I just bought the property next to her a year ago, Your Honor, and I'm not even moving to the property yet. I'm still doing remodeling on the house. The house is not in good condition. I bought it as it is. After moving to the house on the 28th of May, after I closed the house, I came to the property and I saw our husband, the responding husband, and I introduced myself to him and he introduced himself to me. So the first thing I mentioned was I noticed the limbs of the tree causing my gutter to break down and the moss and the other damage to the roof. I was a little bit disappointed that happened, that their trees along the property line causes that. So I just mentioned to the husband, I said, I would like to cut this tree down that is going over my property. He said that is fine. He said you can cut it. So and I just said that's okay. He tried to introduce me to the neighbor. I'm a kind of a shy person. I don't meet people right away. So I said no, not right now. So then shortly after that, in June 8th, I started noticing a foul odor from a property line fence along my property. As the odor so stinks, and I said, what is this? And so I just don't know what to do. And I just say, well, if I ask this guy another question again, he might take it offensive. Since that day, when he walked in front of my house, he would just ignore walking his dog, he would not even wave or anything like that. Just I think it's a good neighborhood thing to do. So I don't know how to approach him. So I called the city, and the city said there's nothing in the law that said they can't put their dog waste along their property line. And I said, okay, that's fine. So I tried to call another neighbor across the street, Mr. Borison, to interstate on my behalf to try to talk to them because I don't know how to approach them. I talked to Mr. Borison. Mr. Borison wanted to talk to them. The next day, Mr. Boris talked to them. This woman saw me. We live on the chain link fence before I put my wooden fence on it. The fence used to be like this, it's a chain link fence. I can see through everybody's yard and everything. She came to me and said, I don't appreciate you going to other neighbors and tell my business to other neighbors. If you have questions with me, come to me directly and tell me directly. And I said, I'm trying to avoid conflict. Yeah, that's why I asked Mr. Boris to intercede. And then she just keep going and say, because I didn't come to her first to ask for her to remove the dog waste, she's not going to do anything about it. She's going to, unless I come to her first to ask her for permission to remove the dog waste. And I said, what is this? So I'm now to avoid commotion or further conflict, I just ignore it. The smell.
A moment, Mr. Saka, before you go forward, let me ask a question. Your houses back to each other, is that right?
Next to each other, Your Honor.
On the side?
On the side. Their property on this side, my property is on this side. Next to each other, Your Honor.
All right. Somebody submitted a map of a property, and I could see your property identified, but I couldn't tell where Ms. McMahon's property was. All right, go ahead.
Yes, so I called Mr. Borison, who lives across from the street from me directly, and I said, well, can you help me to interject? And you went to talk to them. As I said, the problem started, And then the husband come next day and talk to me, say, well, I'm busy at work. I will clean the mess. I'm so tired when I come home from work. And so I said, that's fine. A month go by, since June, July. In October, as I was doing the money on the house, I had the countertop people installing the countertop on my kitchen. As I was looking at my kitchen window and I saw the respondent throwing debris over my fence, some of the pickets I used to do for my fence, she's throwing it back to my yard. And she do it one time, she do it second time, she do it third time. And I said, what is this? So after the contractor left, I went down to the back. She's swimming with her, doing some yard work or swimming, and you can see through their yard because they changed the fence. And I said, why are you throwing stuff on my yard? And so he said, you're trying to kill my dog. You're doing this you're trying to harass me. You're doing this because we're a military family. And I said, this is not true. I'm just doing this because the smell is, I can't breathe. I have to put a mask on. Sometimes when I have to go to my property to do yard work. And I said, can you just remove this? And he said, no, until I come for permission. She taunting me and all that stuff, making fun of me. When I went to talk to on October 17, after this incident, she threw this stuff on my fence, I went to tell Mr. Borison again what happened. I saw Mr. Borison, I said, this is exactly what I encountered with my neighbor. As I was talking to Mr. Borison, respondent jumped. Whenever I'm outside trying to talk to the neighbors or so, she will eavesdrop from me. She will intentionally come out of her property. She just jumped out of her house. She just launched into me to Mr. Borison's property driveway. She was just shouting at me, it's illegal to make a false statement to the police and all this stuff. And I said, what is this? What is going on? So I left. I just don't want to. So I left back to my property. I left. So that incident, I just pretended to sweep under the rug. And then again, on January 23rd, I came to the property. I showed you the picture. My fence appeared to be vandalized. Somebody pushed from the same property, same side with the respondent. So somebody pushed my fence over, and the wooden fence, the pickets, somebody forced it. And I called the police, and the police, when I talked to her, she told the police there's a wind and knocked it down. Your Honor, I put enough barrier protection for the fence to hold it. Plus, they have a shed next to where they have the dog feces that is supposed to be a barrier protected against the wind. It appears that from this side where their property is, somebody pushed the fence and the pickets, everything kind of vandalized. And I said, okay, that's fine. I will fix it. 2 days later, after I do that, the same thing happened again. So I was so embarrassed to call the police again about the same thing. I said, okay, this is a lost cause. So I just keep fixing it when that happened. And then on May 7th, this is the one that's really balling and standing up threatening to my life. I was sitting waiting for the contractor outside. She came outside after I was already in my driveway waiting for the contractor trying to start the lawnmower. A lawnmower couldn't start. And then she went back to the house. And then Mr. Borison, the guy I repeatedly asked to come to the house to help me intercede. She waved him down. He went to his front of our house. They're trying to fix the lawnmower. Everything was okay. And then as I was checking my cell phone to see if the guy texted me about whether he's coming or not, or so trying to check my message, she just yelled from her property, stop videotaping me, stop taping me, stop recording me, stop. She just started making all these accusations that I'm videotaping, taking a picture of a minor child. That I saw, and I said, what is this? And they said, so I didn't respond. When all the time, all the baba attacks she's been doing to me, because she's a female, I never respond back to her. I never say anything back. She always attacked me. So I just keep quiet. I said, she just keep attacking me. So I called the police. And I said, this is what is going on with my neighbor. And the police said they will send somebody. So later on, the officer didn't say they are so busy, they didn't come. The officer, Ben, called me on my cell phone, say we're so busy, but what is this? He said, if things escalate, call us back. I said, okay. And I said, officer, do you have a case number? She gave me an incident number. I wrote it down. While we were still waiting for the contractor, our 2 friends came. I don't show the picture. A male friend and a female friend. They came and joined her on the driveway. And this male friend, when she was cursing me about the stuff before, the male friend also used talking about guns or something like that. So these are the female friend, and this one I don't know if I show it.
Yeah, I saw that.
So they both came, and they don't even know what happened. She's telling them some story, and this guy attacking me again. He's taking a picture of us and all that stuff. And I said, what is this? So I just left it. She made some angry, hatred statement that I didn't want to repeat when they were together. I didn't repeat. Later on that evening, then she came to the property and I was outside. She said, I hate you, I'll kill you. I said, what is this? And I feel so threatened by that. And that's why I came here. She make all this name calling before that I never take seriously. The last time that on the 23rd, when I called the police, came to come and talk about my conduct. 2 days later, she went to put a sign on the fence saying that about firearm and next to my fence to intimidate me, to harass me. And I don't. And her husband served in the infantry unit in the U.S. Army, and make me concerned for my life. And so,
all right. So you're here primarily because things haven't gone well between the two of you up to this point. And on May 7th,
Yes.
you're saying that she threatened you and said she will kill you.
Yeah, she threatened me. She said, I hate you and I'll kill you. And that is the reason why we're here today, Your Honor.
Okay, have a seat. We're going to hear from Mrs. McMahon. Ms. McMahon, go ahead. What do you have to say?
Would you like me to respond to everything that he just said or to everything in the packet?
Well, I know you submitted a 29-page document. I did review that.
Okay.
So I'll let you pick and choose. You can have as much time as he did, which was about 12 minutes.
Well, it's gonna take a whole lot longer, but I'm going to address what he just said.
Well, let's start with this, Ms. McMahon.
Okay.
I don't need a long history about what happened in October of last year and so forth. That's water over the dam already.
It's relevant because he included this in his packet.
Recently, hold on. What's happened recently with the alleged threat on May 7th that you said you hate him and that you will kill him?
Yes.
Go ahead.
Give me a moment. I would like to ask what time I had come outside and allegedly said that to him. Is there a time and date?
The date is May 7th. What time of day? Mr.
Shortly after, two friends left that were attacking me with shortly after they drove.
Well, was that it?
It was about
Noontime, 5 o'clock,
after,
7 o'clock?
about noontime, after noontime. After I called, about now after I called the police. After yeah.
That is incorrect.
What part of it's incorrect? That your friends left at noon or that you came out and threatened them at noon?
Both parts, Your Honor.
Okay. What time did your friends leave?
I have cameras in the front, and they left. We went in at almost 3:00 p.m.
So they were there until 3 o'clock?
Yes. And me and my son, we have a ring bell as well. Actually records us walking into our house at almost 3 p.m. So I would like to know how that happened at noon.
Okay.
Yeah.
Go ahead. What else?
Me?
Yes, you, Ms. McMahon.
Okay, so I touched upon my cameras. Let's see. He did say, now is this all pertaining to May? Is that what we're focusing on?
That's what I would like to focus on. Yes.
Let's see.
He says that in May he called the police twice, and then a third incident happened with you coming to the fence while he was working outside, and you said, "I hate you. I will kill you."
Correct. So, like I said, my cameras record us. Everybody leaving my property around 3:00. When I walked in the house, Mr. Saka went into his house, and he left his house shortly after.
Left the property altogether, got in his car and drove away?
Yes. He also stated today that he was waiting for contractors. No contractor ever showed up to that house, Your Honor.
Okay.
So,
So that he was contacting them to see if they were going to appear. Apparently they did not appear that day.
yeah, apparently. Okay. Let me gather my petition file 11. Let me just give me a moment. I'm trying to find, okay. On May 7th, my son and I were in our front driveway. My son was drawing with his chalk in the driveway. During this time, Mr. Saka went into his car in the driveway and proceeded to stare at us. This went on for 15 to 20 minutes before I went into my garage to grab my lawnmower because I wanted to mow the front lawn. As I was coming out of my garage, I witnessed Mr. Saka with his phone up. I don't know what he was doing, if he was taking pictures of my son or I don't know. I can't tell you. I started to mow the front lawn. All the while, he proceeded to stare at me. Something happened to my mower and it was making this clanking sound. So I pulled it over and so Mr. Paul Borson was walking by, who was my neighbor across, and I had flagged him down to come and help me because I don't know anything about lawnmowers. In the meantime, my other neighbor Hans had also come over and they were trying to help me. During this time, my two friends who run a landscaping and fencing company were already coming over because I had a large tree branch that had fallen from my tree in the front. So they had come over. Mr. Saka proceeded to continue to stare at us, and this about an hour into it. My son also saw him taking photos. My friend, Sandra DeFeo, who is an employee at the sheriff's office there, told Mr. Saka, "I do not consent to you recording or taking pictures of me." He continued anyway. He got out of his car, he put his phone on speaker, and he called the police on us. During this time, we waited for the police to come, but we had called and because we had other things to do that day. And we had asked them, "Hey, is anybody coming out here?" Because Mr. Saka had said, "I'm waiting on the police to us." We called to verify that anybody was coming and they said no. We had already called him back and told him that nobody is coming out here. So at that time, that was almost 3 p.m. according to my cameras. My friends left, and then me and my son also went back into the house. Mr. Saka went back into his house maybe a minute later, and then he left that property not too soon after. He stated in his police report that my friend had a bulge in his pants. My friend does not carry or own any firearms. Just to let you know about that as well. Let's see. According to the police report, the next day the police report states that Mr. Saka called back with quote unquote more to report, but it does not specify what that was, so I'm not exactly sure. So Mr. Saka stated, "I hate you, I will kill you," apparently at noon, which is incorrect. I have a total of 7 witnesses rotating there in that 2-hour time period that can attest that I did not say such a thing. Later on in the statement in his packet here, it says that I threatened him with a weapon. In the police report that he provided, it says, it doesn't say anything about a weapon, so I'm a little confused about that, since I do not own a firearm or carry a firearm. He also states he believed death or serious physical harm could occur within a short time in this protection order on page 4. Yet this was not stated to the police when he called, nor did he stop staring at us or leave the premises when the cops had told him to 3 times. He did not call 911, and let it be known that Mr. Saka filed this order on May 26th. This occurred on May 7th, I believe. So that's 19 days in between. So if there was serious immediate harm or irreparable injury that could be caused immediately, why did it take 19 days to file this protection order? Let's see. I believe that Mr. Saka has also stated in his packet, page 1 of the written statement, that the respondent conduct is escalating while, quote, annoys, harasses, alarms, and serves no lawful or legitimate purpose. Such wording is seen on the district court's website under protection orders.
Okay, lady, I'm sorry, but when I last night was, let's be honest, super turned on when Judge Dismissal Dan was correcting somebody on their spelling because they were being a dick, I am like, that's a one-time thing. You don't get to do this in court. Who the fuck do you think you are? Lady, I don't know how this is going to work for her. Let's keep watching because it's live and we'll miss it.
Word for word. I don't know if that is completely relevant. On the same page 9 of the petition for protection, Mr. Saka writes, the respondent could have carried out the threatened action. I believe he's referring to a firearm that does not exist. I'm not exactly clear on that. The respondent communicated directly her intent to kill. This petitioner reported the threat to the Lacey police, but none of that is in the police report provided here. So per the report, Mr. Saka provided his statements made on the 26th do not match what the police have in his report from the 7th. The discrepancies garners further look into these claims. And this is all I have for May 7th, I believe.
All right, let me ask you a question.
Absolutely.
This issue of the dog waste.
Yes.
I know there was a letter that came from the city of Lacey about that. Did they come to the property and look at it? Or did they just say you have an obligation not to collect dog waste on your property?
Nobody came to my house. I work from home. I'm here all day. So nobody came to my property.
All right, so they just sent you they just sent you a letter saying
Apparently.
you can't do this.
Yes, but the letter, I did not receive that letter, and that was in January.
Alright.
Yeah. And I spoke with the code enforcement officer directly last week about the letter, and he said that it wasn't a fake because it looked kind of fake and weird because it didn't have a phone number or an email address or anything. So I spoke to him directly. He said that he did not receive a receipt because it was a certified letter. So that means I did not receive it. So I do not know what happened to that letter. I don't know.
But he acknowledged that he sent the letter.
Yes.
Okay. All right. Anything else you want to tell me about May 7th?
Oh, give me a moment. Actually, I would like to speak about the accusation of the firearm. I'm just trying to find my page here. Page 11.
This lady
I cannot
is
number my
walking-
pages. Give me just a moment here. Oh. I apologize. I'm frazzled.
Well, let me ask you, did you add that sign to the fence or had it always been there?
That was there since the end of January, Your Honor. And I provided the receipt from when I purchased it in the packet there.
And what was your intent at the time of putting that sign up?
Because my son and I were playing in our backyard and we witnessed Mr. Saka staring at us through that side yard there. So I wanted to put up some privacy on that side. And since my husband is overseas, and it's only me and my son, I believe that I put it up to protect us, to protect my home and my property.
All right. Mr. Saka, do you have anything you want to say in response to what
Yes, Your Honor.
Ms. McMahon said?
To start with you about the gun display was after 2 days after I called the police when she put that sign down there. You know?
Incorrect.
2 days after when police came on January 23, that's when she put that sign there shortly. But she only put that sign on my side of the property. She has another neighbor next to her, the house next to her. There is no sign like that down there, you know. That's number one. Number two, about the police report procedure, you know, Lacey Police Department takes almost forever to get police report. After the incident, I went to them to talk to them. They said, wait a while before we can get it to you. That's why it takes me a long time before I file a report. About the time frame, she said, I don't know the exact time. When Your Honor said noon, I'll just approximately about noon. But she made that comment to me. She knows, and God knows in her own mind that she made that comment. I don't expect her to say I did that. I don't expect her to say that. I know she's going to deny it. You know, with all this coming to my property and attack me, verbally attacking me, coming in my property, making fun of my accent. I have a picture of her in front of my property. Yeah, coming to attack me and calling me names and follow me across the street to somebody else's property. That is not proper, That is not. I need to protect myself from this person. I need the others to prevent her from doing any act like this in the future. Either coming to my property or follow me to Mr. Borison's house and coming to molest me and harass me. And when I'm talking to the neighbors, I need something to protect myself from this woman. I talked to her husband when I first bought the house. She told me she served in the infantry unit at the U.S. Army at the Striker Brigade. And, I've seen a sign of weapon in their house. And
You have seen what?
I've seen, what do you call this? Case of weapon stuff in their windows in their house along that property. They have a window facing my property side. It's like a window like this, they have a case. You can see it from the outside. They have a case shell of a firearm display on the.
All right. So let me ask you: have you ever seen a firearm other than in that safe, gun safe?
No, I have not
Gun
seen it.
safe?
There was never a firearm. She never showed you a firearm.
She never did. But
All right.
based upon that,
Did she ever threaten you with a firearm?
yes, she does. She
She
does.
threatened you with a
She said,
firearm?
I'll kill you. I'll kill you, with a poster like this on the fence. He just it doesn't take a rocket scientist to figure that somebody's going to kill you. He's probably going to use a gun that she's display on the fence to kill you, And her husband served in the infantry unit of the U.S. Army. And I know, for God knows, they have a weapon in their house. I know they have a weapon.
But you haven't seen a
I
weapon.
haven't seen. I see
Right.
the display
And
of.
they didn't threaten you with it. She did not threaten you with a weapon. When she allegedly said to you, "I hate you and I will kill you," she wasn't holding a weapon in her hand.
No, she's not.
No. Okay.
That's incorrect.
What's that?
He stated in his packet, I was holding a weapon. In the protection packet there.
He hasn't testified to that here today.
It's in the
And
packet.
in fact, he testified that he didn't see a weapon and that you weren't possessing a weapon.
Interesting. Okay. I do not have a gun safe. I'm sorry. I didn't catch that about a gun safe. Could you repeat that?
Well, I called it a gun safe. He said he saw a cabinet through a window that has guns in it in your
Oh, a
home.
window. How? How do you, where?
I don't know. He
Any
just said
window.
he saw through a window a cabinet that had guns in it.
On the side of my house?
Display case on the wall. If you have a window like this, through the house. The window is so lower. When you walk down there, you can see
All right. So did you see guns in a case?
No, I didn't see the gun,
What?
but I have a display of a gun, a rifle.
A what?
Rifle on a shelf. A display of a rifle on the shelf when you walk down along that property line. You have a window similar to this,
I understand what you're saying.
Yes,
Your
He's
Honor?
saying, Ms. McMahon, he saw a gun on a shelf through a window along the property line.
I can go ahead
Is that
and take you
possible?
down there right now. No, I can go ahead and take you down there right now.
Did you ever have a gun there?
No, Your Honor. That is extremely confusing because all the curtains are closed downstairs because we never.
You just lied. I fucking call it right now. No, Your Honor.
Go down there. And the room he might be talking about, I'm not sure, is our guest room. And that's where we kept our kitty litter box, and there's a dresser down there. That's about it, Your Honor. We don't have anything. I can take you down there.
Okay,
I'm
that's
so
fine.
confused right now.
Let's kind of recount what we've heard here.
Gosh.
Mr. Saka, I agree with you that this is a difficult situation. That if all what you say is true, it must be unpleasant for you to have to be present when you're there. Am I correct? You're not living in the house right now.
Yes, the house is still.
And you've owned the house for how long?
Over a year now. I couldn't have find money to fix everything that needs to be fixed to be habitable.
And so where do you live otherwise?
I'm staying with my wife in Puyallup right now.
Puyallup, okay. How often are you at this residence?
I'm almost there every other day, every day.
That's incorrect.
So I agree, Mr. Saka, and I guess with you as well, Ms. McMahon, based on your written response, that this is a difficult and unpleasant situation. That doesn't make it at all easy for the court to be involved in this, trying to tell one party or the other to back off and to be more respectful of the other party. It sounds as if both of you at times have had difficulty being respectful of the other party. There is a concern on Ms. McMahon's part that you're taking photos of her and her son and you're staring at them for some reason. I hear from you, Mr. Saka, that you're concerned about this dog waste issue and other things of that nature. And then, of course, this threat that you're saying she made to you that she's going to kill you and that she put a sign on the fence that leads you to believe that she may have a gun and that she may be planning to use a gun or thinking about using a gun or something with a gun that could affect you. Ms. McMahon raises a good point. If this allegedly occurred on May 7th, why did you wait until May 26th to file the order?
Due to the police report, I came to file anti-harassment order in January, and they told me that I need the police report to substantiate my claim. So that was why it takes. I went to the police department shortly after the incident. They told me it's going to take a while for them to prepare the report. That's why it takes so long to file the paperwork. In addition to that, Your Honor, this respondent repeatedly come to my property and attack me. That is trespassing down there. I need some order that will prevent her from coming to my property, at least, so she doesn't come to my properity. I have a picture in here among the evidence I submitted.
I saw you said that she was on your property.
Coming, videotaping me, calling me, name calling, making fun of my accent and all that stuff.
And that's my point, Mr. Saka. If what you're saying is correct, she's being disrespectful of you. If some of the things that she said in her response that you've done are indications that you're being disrespectful of her, that something to the effect that you will not deal with a woman. Now, I don't know if that's so or not. We don't have testimony from third parties that are independent that have nothing to do with you or her. What I have is you saying she did it. I have her saying she didn't do it. I don't have a basis to enter an order at this point. What I can say is the two of you are setting the table for each other here to get in more trouble. You both need to back off of this issue. I don't know what happened with your fence. You say it was vandalized. Ms. McMahon says the wind blew it down on a couple of instances. She even submits documents showing what the wind speed was on those particular dates and times. You say she did it around noontime, made the threat. She says her friends were there until 3, and then you left shortly after that, and she never saw you again that day. I can't find a basis where she said she made an individual threat to you that she had the intent or the likelihood to be able to carry out that would put you at this risk of distress. Again, waiting 19 days for a police report to come, which I don't think verifies what you're saying, that she threatened you, that she was going to kill you. The purpose of this court and this proceeding is that if a threat like that is made, you can come here right away. You don't have to wait for the police on something like that.
Listen, Your Honor, I didn't know that, Your Honor. I was told I need to bring all the evidence, anything to substantiate it.
Yeah, but the police report doesn't say that. The police report didn't see it. There's no independent witness to verify it. It's your testimony essentially against her testimony at this point. We have all this other extraneous stuff about the fence and about the dog waste and you know, who's talking to Mr. Borison and who isn't talking to Mr. Borison and all of that. What I can say to you is, to both of you, is to back off. Mr. Osaka, you come and work on your property. You have your contractors come and finish that property. If you need to trim the trees, apparently you have permission from McMahon's to do that. Ms. McMahon, I have to suggest that you might be a little sensitive about him and his phone, whether he's taking pictures or what he's doing with that, or him staring at you under whatever the circumstances might be. But I don't have a basis at this point to enter the order that you're asking for, Mr. Saka. I simply don't. It's conflicting testimony, no independent witness to testify one way or the other as to what happened. Just too much of a gap between what is being said and what is being admitted, what is being denied. So at this point, Mr. Saka, I'm going to deny your request. That does not mean that you can't come back again at a later time if something else happens. If you can get somebody to independently verify it. If Mr. Borison hears her threaten you, then get Mr. Borison to come in and testify to that effect, or write a declaration to that effect. But at this point, we don't have that. We have two neighbors who are, for whatever reason, unable to be neighborly to each other. And that needs to be changed, because the two of you presumably are going to live there for a while and be neighbors. I'm sorry, Mr. Saka. I'm sure you don't like that response because I denied your request. Ms. McMahon, you probably don't like it that I'm telling you, you need to be more respectful. But that's what I see when I read these documents. And there are lots of documents filed by each of you in relation to this. The police aren't the answer for things like dog waste and alleged threats over the back fence and so on and so forth. It's difficult under the circumstances for the police to be able to establish enough evidence for probable cause to arrest somebody. Putting an order in place at this point will increase the risk that somebody's going to get charged with a criminal offense. And that's not necessarily the case here. I don't think any of this behavior rises to the level of a criminal offense. So that's my ruling. That's my decision. I'm going to sign an order saying that the order is denied at this point.
Denied. Wow. This hearing could have taken 4 hours with some judges. Seriously. Gosh. Judge Woke. Oh my God. She'd be like, do you have a sample of the poo? And would we be able to get it genetically tested to see which species of dog it is, or which breed of dog it is? Thank you, Tupac. Appreciate that. Wrecked. Yeah, this is your Friday, right? Is that how it works for you? Thank you so much. I've made a new graphic for it. Let's see how it looks when it comes.
Oh, yeah.
Streamy sounded a bit sick there, but I love it still. Oh, yeah. Okay. What are you filling out, Josh? don't know why they're still here, but I'm afraid to leave because sometimes the best stuff happens right at the end. Plus, I'm just drinking my first cup of coffee for this morning. If you haven't liked the video yet, please do that. Please. Also, we're going to be jumping from court to court hopping today. So we'll be switching somewhere else. What I'm gonna do is actually pull up my my live page, and we'll pick something that looks good. I know I need to make cookies next, but I don't want to make. Valentina, are you talking about me or her?
I've signed an order denying the request for a full protection order. And the reason for that, the basis for that is I do not find that the evidence reaches the level necessary for an order to be issued, that be a preponderance of the evidence. At this point, the case is going to be dismissed, and no additional service will be required, so you don't have to do anything else, Mr. Saka. You'll get a copy of this before you leave. Ms. McMahon, you can get a copy of this order from the Thurston County District Court website later this afternoon. No other hearings in this case. And that's it for today on this case. So if you'll hang on for a minute, you'll get a copy of that, all right?
Thank you, Your Honor.
She should
Hang on for just a second, Ms. McMahon. Make sure I did it all right.
Ooh, she looked a little scared there. I haven't yet decided on cookies. I'm sorry if my volume isn't good. I don't know why. It should be.
All right, Mr. Saka, thank you. All right, Ms. McMahon, you're good to go. Thank
Thank you,
you.
Your Honor.
All right, I think there are two things left to do. Right. Okay. And that was the 20th we set that one for, right?
Testing, testing. Am I the same volume now? My daughter asked for chocolate chip cookies. I have a special recipe. I do have the ingredients. I did say I would make them. I probably will. I probably just need about 3 cups of coffee. Now I was lower?
Both of them appear?
No.
just Ms. Aiken, right? We're thinking it was last minute service.
Last minute service. That's never good. I bet that's even lower. Gain. Yeah, well, it's my morning, God rides a Harley. I did a late night stream last night and I found some amazing new courts. I may have slept less than required.
That one. And did we deal with number 11, Wire and Pistano? Neither one appeared there, right?
Valentino, I made chocolate chipless cookies recently. Same recipe, but minus the chocolate chips, and I was almost attacked by my family. No, I don't bake a lot with pot because it's not my favorite way of doing it, but sometimes I know how. Um, Honestly, the problem with baking delicious items that are filled with pot is that can't eat them all. So it's probably not the greatest idea to make delicious things because people just want to eat them. And they can't because they'll get too high. I used to think that they should sell a package of like gummies that were non medicated and then along with like the one medicated gummy so that you could eat like the pack of non ones and the one medicated one and not get all messed up. So this judge, oh my God, you're slow, judge. Um, no, the best way to the pot up the bum, Jonathan, is to not be high. That avoids the highness because you bypass the liver. Therefore, the psychoactivity of the THC is bypassed in the mechanism. So it is not it is not to get high when I say
Do we have one more?
take it up the bum.
Or is that the last? Did we deal with number 13?
No, we still have that one too.
Okay. Yeah, we can go off the record.
But when oh, okay, Judge, sure. Hold on. But when you are dealing with marijuana for medical purposes and you're trying to take high doses, which is what the protocol is if you're thinking of for cancers or something like that, the dosage is usually dependent upon how much you can tolerate to be high. Whereas if you do it with suppositories, you can actually get very high dose THC without the psychoactive effects, and therefore you get the best of both worlds. Okay, let me just grab the screen here. We're going to take a look and see what is live and what you guys would like to watch. Let me just see. Okay, we have a lot of different courts. We're probably what maybe what we should do is like a scroll and then a stop, like and just stop on whatever suits our fancy. What you'll see here is how many court channels I have, which is like a billion. Hi, Crystal. You were watching Judge Washington earlier? Let's see here. I was watching, although just give me a second, you guys. Just give me 1 second, please, because I want to get that whole hearing. So I'm just gonna do that while you wait. Okay, so let's see. We've got live court. Oh yeah, there's lots of Travis County first appearances. I have a bunch of things, but I wanted to find some live stuff. Jail people. That looks good. Come on, guys. Jail people. You gotta be kidding. You can't write this shit. You cannot write it.
Eye history.
Okay, what's your name, sir?
Nicholas Rukoff.
All right, Mr. Rukoff, you're here on a 48-hour affidavit. No formal charges are filed in your case yet, but I'm going to set your bond today on the possibility of charges being filed of aggravated domestic battery, 2 possibilities of that charge, domestic battery, and then criminal restraint. What's the county attorney's position on bond for Mr. Rukoff?
Your Honor, these would be 2 level 7 person felonies. I've looked into Mr. Rukoff's criminal history. He is an I, as far as I'm aware. The state would request a $10,000 bond, or alternatively that he be released to supervision with court services, along with a no contact condition with the alleged victim in this case.
Okay. Mr. Rukoff, I'm going to give you 3 options. $10,000 is your bond. You can pay that. It's going to be cash or commercial surety, so you can see a bondsman, so you can pay a percentage of it if you want to do it that way. If you want to get out on a known recognizance bond, I'm going to have you required to be monitored by Mr. Iden's office right there. You can see him on the Zoom. That would be a court services bond. Is that something that you're open to?
What would the one with Mr. Eden entail?
He's going to have some monitoring situations that you have to follow, some things that you have to do. I'll also have some conditions of bond anyway. I mean, you can't possess or consume any illicit drugs or any alcohol while you're on a bond. You're going to be tested randomly through blood, breath, or urine. So you can't have possession or consumption of any alcohol, any illicit drugs, right? If you do, you're going to be rearrested. You can't have any contact with Miss Torok, T-O-R-O-K, I believe. I don't know if I pronounced that wrong. You can't have any contact of any kind, no face-to-face, friend-to-friend, social media contact of any kind. If you do, you're violating your bond. You're going to be rearrested, all right? You have to stay in contact with your attorney, and you have to make all your court dates. Mr. Iden's office is going to have requirements for them to have you out under their supervision, all right? They would send a document over, a paper over that you would fill out, an application. If you qualified for that supervision and you were open to it, then you would be released out of jail without paying any money. So I'm going to leave it at that. Mr. Iden's going to send you over a document. If you choose to do that, it's going to cost you $15 a week. You'd be out though. Okay. Do you have any questions for me?
I do not know.
That's all I have for you. What's your name?
Terry Wilt.
Terry Lynn Wilt, you're here on a first appearance. You received a warrant. I can read that warrant to you in its entirety, word for word, or I can just read you the shortened version. Which would you like me to read you?
I understand what I got.
Okay, I'm required to read you at least what you're charged with. 2 counts. Count 1's aggravated assault. It's a severity level 7 person felony. If you're convicted of that, has a maximum sentence of 34 months in prison, a minimum sentence of 11 months probation, maximum fine of $100,000, and then aggravated assault, severity level 7 person felony. It's the same possible charges, 34 months in prison at the high end, 11 months probation at the low end, and then a $100,000 fine. Do you understand that?
Yes. Is there a way I can do like an OR bond?
We'll get to that.
Okay.
You're being held on a $20,000 bond. At that bond hearing, were you allowed an own recognizance bond if you were being monitored by court services?
What was that? What was that?
I don't think you were.
I don't believe so, Your Honor.
Let's go through the next thing, and then we can talk about that. You do have a right to an attorney. You have a right to have an attorney appointed if you can't afford an attorney. What is your plans with attorneys, Mr. Will? I believe you have.
I have to have one. I have to have one appointed.
This morning. You apply for one?
Yes, I did.
Okay, I think I approved that. You're going to be appointed an attorney here shortly. You can talk to that attorney about getting your bond changed. Is the state open to an OR bond, or you want to wait until it's held in a bond hearing?
Your Honor, I reviewed Mr. Wilt's criminal history a little bit more in depth than last time we were here. It does look like he is going to be an I history with some prior arrests and possibly some misdemeanor convictions, or at least one, but no person felonies or person crimes that I'm aware of. I would be okay with him being released to court services supervision if the court's okay with that and court services is willing.
Mr. Iden, any objections to sending over an application?
No objection to the application. My 2 questions will be, does he reside in Hayes, and are there any no contact orders in place?
There is no contact order.
Is it with
I do reside in Hayes.
Okay, so
I
with the
believe it's
potential,
with his neighbor. If I remember the case, but I'm not sure if I remember the entirety.
Yes, sir. My neighbors are across the street.
Okay.
so then I would guess we would need Your Honor's guidance on how to approach that.
I mean, he's just not going to have some direct contact. Obviously, he's going to live within, 50 feet of them. He's just going to have to not go out of his way to contact them, I mean, whether it be driving by, making hand gestures, he just can't have any contact. I don't mind that he's out on an own recognizance bond. He still has that no contact order. He's just got to be very careful as to how he interacts with that
Can I say one thing on that too,
What's
sir?
that?
Is I don't leave my house sometimes. I play on a computer 24 hours a day, 7 days a week. So that should be okay with me. I'd never be outside unless I go fishing with my my roommate. And usually we're not even.
No, I think that Mr. Wilt and I will discuss exactly what parameters he can use to remain within compliance, but we'll send an application over for him.
Okay, you're going to be set for a status hearing, Mr. Wilt. Okay. I don't know when court services is going to get with you. Today's a busy day in Ellis County District Court, so they may not get with you today. It may be tomorrow. It may be Wednesday. I just do not know. You understand?
Yes. Okay. Do I have to stay here until then?
Yes, you do.
Okay.
We'll get you the application today. It'll be a matter of when we get it back and what information we need to process on it, but we'll start the process this afternoon.
Okay.
All right. Anything else from the state?
No, Your Honor.
Okay, that's all I have for you, Mr. Will.
All right, thank you.
Yep.
Just give us a minute, Your Honor. We got to relocate to where the other one's at.
Yeah, that's fine.
Dead air.
Yes, sir.
Mr. Nixon, you're here on a 48-hour affidavit. No formal charges are filed in your case. I'm going to set your bond today. And your conditions of bond, looks like you have possible charges of aggravated battery, domestic battery, driving under the influence, transporting an open container, driving while suspended, failure to maintain a single lane. And what's the county attorney's position on bond for Mr. Nixon?
Well, Your Honor, it appears with the limited information in the affidavit that this is likely going to be charged as a level 7 aggravated battery, along with multiple misdemeanors, all class B or lower. I reviewed criminal history through III. This individual, he has several cycles, but no convictions of anything. So I would believe that he would be an I history as well. The state would request the same bond as the last individual, $10,000, or alternatively, if court services is open to supervision, that would be fine as well, along with no contact with the alleged victim in this case.
Okay, Mr. Nixon, I'm going to set your bond at $10,000 cash or commercial surety. So I am going to let you bond out by paying the bond or paying a bondsman. Also, you could be monitored by court services. In fact, I actually checked that you shall be monitored, which means you have to be monitored whether you pay the bond or you don't pay the bond. It's going to cost you $15 a week to be monitored. So court services, a court service bond would actually let you bond out through an own recognizance without paying money, but you have to follow their bond conditions. You understand?
Yes, sir.
They're going to send you over an application. Make sure you fill that out in its entirety, okay?
Sir.
And you have a local address, right?
In Victoria, Your Honor.
Yeah.
But that's where
okay. Ellis County. You're good. All right. Anything else? Oh, you have a no contact. Here's my bond conditions. You have no contact with Chelsea Conrad.
Anywhere else to go? Your Honor, he's saying that he has nowhere else to go. That's where the victim lives.
That could be a problem. So you're going to have to work that out. So there's some things you need to work out here because you have no contact with Chelsea Conrad, no contact of any kind, no face-to-face, friend-to-friend, social media contact, no contact of any kind. You understand?
Yes, Your Honor.
Okay. Also, no consumption of any illicit drugs or any alcohol while you're out on bond. You're going to be tested randomly. If you come up positive for any of those substances in your body, you're going to be rearrested. You understand that?
Yes, Your Honor.
And make all your court dates, and if you get an attorney, stay in contact with them. So if those court dates change, you'll be aware of that. And anything else from the state, Mr. Rutherford?
No, Your Honor.
Also, Mr. Nixon, if you change your address, let the county attorney's office know of your new address so you can get mail there, all right? If they send you out mail. And I think that's all I have for you today.
Thank you, Your Honor.
And I believe that's all I have with you, Mr. Rutherford. Is that correct?
That's correct.
Well, okay, that's all we've got. Let's find another court then, folks. We can go to Kansas, first appearances. We can go to Bromlett. That one looks sort of interesting. Everybody's on their phone here, lazies. Yet I'm the one that would get in trouble in court. Did he have like a quoted middle name on his Zoom profile there?
Truly do need to individually, and you need to speak with the therapist. And that's going to be part of my order here is you need to go and have an evaluation with the therapist and see, get a plan. Because once you work on your internal struggles, you'll be able to work on those external ones too. Okay, and you'll be in a better place.
Okay.
This, in the essence, these cases, you have a drug problem, you have a drug issue, and that's where the correction needs to come in, and that's where the hard work is going to come in. The difficult part here is the putting the children in harm's way or the potential to have the harm because it's occurring in your home, and this has been allowed by you to be in your home. And that's the most serious part of these cases. Otherwise, we're talking drugs, drug issues, drug problems. But children are children, and they can't defend themselves. They can't protect themselves. They need you to be the mama, to be the one to protect them. And that means clean and sober household. No drugs, no alcohol, nothing allowed in. If it has, especially alcohol, if it tends to be able to be abused. This is not a prison case up front. Maybe it is down the road, but not at this juncture. Again, this is a use case and violations of bonds when you knew you were on bond. I do believe that a probation sentence is appropriate, so I will follow the recommendation as it relates to probation, 3 years of probation. Again, looking at the facts of these cases, and if you're revoked off of probation, I don't necessarily think that these are prison cases either. And so I'm not going to do a withheld sentence because otherwise you have all of those years. You have 12, 13, 14, 15 and a half years hanging over your head, okay? That's a long time to have hanging over your head. These aren't prison cases. These are cases that you're going to need to know what's going to happen, okay? What's going to happen if you're revoked, if you don't get things in order and you don't start dealing with your trauma. I think that right now you have, my clerk was able to confirm 66 days of jail credit, okay? So you have 66 days of jail credit. If you're revoked off of probation,
And we're switching. She's boring. I don't like her.
Days in
It's
Rogue
still-
County immediately preceding the filing of the complaint for divorce.
yes.
Is it true that you and your husband were married September 27, 2014 in Sylvania, Ohio? Is it true that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved?
Correct.
Is it also true that you are not pregnant?
Correct.
Is it true that Cameron and Maverick were born of the marriage?
Yes,
Are the dates as reflected on the complaint correct?
that's correct.
And is it true that there were no children born or adopted out of the marriage?
Correct.
Are you asking the court to grant your complaint for divorce but reserve all issues?
Correct.
Okay, no further questions, Your Honor.
Thank you, Ms. Kuhn. Mr. Leibovitz, do you have any questions of Ms. Boland?
Nothing at this time.
Well, perhaps questions for Mr. Boland, please.
I have a couple things. First, you heard the proposed interim agreement between you and Ms. Boland, correct?
Yes.
And do you have time to think about it?
Yes.
And it's your decision to consent that this will be the interim governing order until we come back to mediate on the 10th of August at 1:30?
Yes. and you wish the court to enter in this temporary interim order.
Yes.
I did have a couple qualifications of the agreement for the appraisal is not to exceed $500. Additionally, Ms. Bolin does plan to move out of the marital home this coming July 1st, at which time Mr. Bolin will be responsible for all of the financial obligations concerning the marital home, and likewise, Ms. Bolin would be responsible for all of the financial obligations of her new residence.
Ms. Kuhn, is that those clarifications agreeable and acceptable?
Yes, Your Honor. Mr. Bullen will be paying the mortgage and all the utilities and taxes, anything pertaining to the home commencing July 1st. That's correct. And yes, yes, with regard to the fee as well for the appraiser.
Okay, so the maximum Mr. Bullen will contribute is $250 toward the appraisal. Well, obviously, we still need an appraisal.
Correct. Mr.
Right.
Swear is $495, Judge, so we're not going to have a problem.
Okay, right, very well. Mr. Levens, I guess last, can you confirm with Mr. Bolin that the testimony of his wife was true and accurate to the best of his knowledge, please?
Was the testimony of your wife true and accurate?
Yes.
Thank you, Mr. Levens. Ms. Kuhn, do you have any questions for Mr. Bolin?
I do not, Your Honor. Thank you.
All right. Who will prepare the interim order?
I will, Your Honor.
All right, thank you, Ms. Kuhn. Anything further, Ms. Kuhn or Mr. Levens?
No, I think we're good, Your Honor. Thank you.
All right, Mr. and Mrs. Bolin, it's wonderful that two of you can co-parent your two children. They will benefit without question. The fact that the two of you can resolve this matter amicably. The reality is, it's in their best interest, better than anyone in this world. And they will sense that they're getting old enough where they can sense there's animosity and tension, and they'll do well if you can both communicate. You need to be on the same page for their benefit, and they will do well in life. Lastly, the best resolution of any case of this nature is one in which you both participate and ultimately agree. Far better off than having this court decide things and liquidate things. So keep an open mind as you continue your mediations. You're both represented by two very capable family law practitioners. So the court's confident you'll be able to work through things together. In any event, if there's nothing further, the court will find that based upon the testimony that's been presented this afternoon, as well as plain follows matter, that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the obvious matrimony has been destroyed, and at this point in time, there appears to be no reasonable likelihood that the marriage can be preserved. The court will, however, reserve all outstanding issues and order that the parties engage in mediation with Mr. Pratt once again on August 10th, 2023 at 1:30 p.m. and subsequently appear before this court for a continued pretrial conference. Court will mail out written notice to counsel regarding these dates. Right, that will conclude this pretrial conference. If everyone could zoom up.
Okay, cool. Thanks, Judge. Well, okay. I have a bunch of stuff that I want to watch with you.
And not deal with.
Not you, lady. You're still talking. Oh my God. Not her. A round table.
Fine. Just please do not let him on his own. He is not capable. And I have more evidence to support that.
Thank you, Ms. First. So, Your Honor, what I guess, getting to the final point, I guess what my request would be is that the no contact provision, he not be prohibited from going back to the residence, that it be crafted in such a way that he's to have no direct contact with those two individuals. I guess no assaultive contact specifically. I'd ask that he be placed on electronic monitoring before he's released, and that the court delay his release under CRLJ 3.2 F2 so that he can be evaluated by a DCR. While that is being done, that has to be done within 24 hours. While that's being done, I can contact Adult Protective Services, or Miss First can contact Adult Protective Services and get them on the radar for him, so that when he is released from the jail and is back at the residence, APS can send somebody to give him that direct assistance. That it would be somewhat awkward for Miss First to do that given the situation now, but at least we can get him some services from APS.
I'll go along with that. If you can prepare an order of those lines that the jail feels comfortable that they'll they can function with that.
Sure.
I guess we'll sit there and see how we'll do, and I guess we'll have to adjust things as we go through the experience, I guess. But
I have chronic pain, and the ibuprofen that they're giving me is I've also had bleeding ulcers, and the ibuprofen that they're giving me is just making my ulcers worse. And Tylenol they're giving me is like putting a Band-Aid on a gator bite.
Okay, well, that's one of the many needs that you have, Mr. Street, and those are the things you're going to have to start working on. And so, what we're going to try to do is to allow you to be out of the jail setting and be home with some adjustments for everybody.
I got to be here another 24 hours to be evaluated. I don't think that's fair.
And Your Honor, I think the court should have a proposed minute order. At the time, I didn't include the EHM component, but the court should have a minute order delaying his release under 3.2 F2. There's a note section. I can redo the order and resend it to the court, or if the court wants to add the note regarding that he's to be placed on electronic monitoring prior to release, however the court prefers.
I'm so sorry, but what is electronical monitoring?
I guess I think that where we have to start is to have an order presented, and we all are party to it. And then I guess, how long do you think it'll take you to draft an order? That's not a very fair question, I understand.
No, I think that, but I'm saying the court should have the order. I email Miss Sutherland emailed it to the court. It should be in the court file, the proposed order.
Go ahead and amend the order you have. I don't have access to email while I'm on the court.
I sent it to Mark and Melissa.
Miss Freeman should have gotten it as well.
There's only 2 bedrooms in that house. That means my wife will have to stay in the bedroom with my daughter.
Do you have that order with you, Mr. Murphy?
I do.
Okay, so you got the first page there. I'm going to go through this. So, do not cause, tempt, threat, but I'd agree with that. I'm going to initial it. The second one, do not contact. This is going to have to be modified then.
Yeah, I have no objection to the court just striking that condition out. They're going to be living in the same household. I think it's that first line that the court just referenced is the key component that we want to have prohibited.
Third one, do not contact, enter, remain, or come within. Strike that?
Yes, Your Honor.
Strike what?
3, do not possess any firearms. I'll initial that.
Oh, friend, thank you for stopping by.
Do not have
we're
any
doing the live grind. I'm showing off
custody or control
random
of firearms, dangerous weapons, etc. I'll agree with that. Mr. Street, do you have any weapons? Any guns?
No, sir.
Do you have any knives or bazookas
sir.
or any of that kind of thing? All right.
No, sir. My only one that has a weapon is my daughter. My daughter has a weapon. I do not know where it's at.
What is it?
My daughter has a weapon, but I do not know where it's at.
Not yours, right?
No, sir. I have never had a weapon.
I'll leave the box. I'm gonna approve 3 immediately surrender. I'll approve that. Apparently it doesn't have anyway.
My only weapon is my little chihuahua.
On number 4, paragraph plain 4, Mr. Murphy.
Yes, Your Honor.
On, what do you want to say? There's no contact order.
I just put 5 years from today's date. That's the placeholder. The court, it's a pretrial order, so it will expire when the case resolves.
Give me a date.
So then that would be June 5th of 2028 at 11:59 p.m., Your Honor.
June 5th, 28?
28, yes, Your Honor, at 11:59 p.m.
$2028.
Okay, so under 5, domestic violence 1099, that's correct. Under 6.
Yeah, so the court should have 2 orders. The one the court's reviewing right now is for Miss First, and that's a family or household member. And then 7, I have 2 boxes marked for the proposed order. And those are connected to the conditions in 3 that the court had marked regarding surrender of firearms.
Yes.
So those 2
You want the
boxes.
2?
Yes, Your Honor. And 7, I'd ask the court to initial next to the 3rd and 4th sections of 7.
Okay. And I just initialed those. All right, so.
Has my wife requested a no contact?
Civil standby, how about that?
I left that blank and I don't think it's needed because he's not being removed from the household. So I don't think the court has to address that. And then regarding 9 and further service, he's going to receive a copy of this order after the court signs it. So he won't need further service.
And PennCon. Okay, go ahead and sign it then.
Yes, Your Honor. And the court should have, that's an order from Ms. First. The court should also have a no contact order regarding Miss Delphine 3.
Yeah, let me finish off this one and then I'll.
Sure. And I can go through with the court again to make sure that they're both consistent with what the court wants it to be.
Yeah. Well put.
Well put, but not making me interested. So we're going to switch to a different court. One that is probably sure to give us something good. So, give me a moment. Also, I hope the audio is better. I have no clue. Maybe I messed up the settings. You know how I play with settings.
Can you both hear mute? Okay, can you both hear us?
Yes, I can hear.
Okay, just one moment, please. We're already live on YouTube. And I just need to get us started here. Okay. The 37th Circuit Court is back in session with the Honorable Brian K. Kirkham presiding. It is Monday, June 5th, 2023 at 1:30 p.m. This is case 2023-1119 CB, Christopher Fanta and others versus Jacqueline Brayman and others. Attorney Seth Tompkins for plaintiffs and Attorney Peter Valiotis for defendants.
Good afternoon, gentlemen.
Oh, sir.
Enlighten me, Mr. Tompkins. I'll go to you first because you represent plaintiffs. What's happening in the case?
We have come to terms on a very detailed term sheet for settlement. And we would actually like to submit a stipulation in order to stay the case for 21 days while there's a lot of moving parts in the settlement so that we can get the actual settlement agreement and all the ancillary documents drafted and hopefully take this off your docket.
Okay, well, the court will be pleased with that. So yeah, if we're just going to stay it for 21 days, that's fine. Get it signed and sent in to us so we have something in the file.
Yeah, and Your Honor, Seth and I have talked about this, but I would request that we have 2 weeks from the lifting of the stay to file an answer or responsive pleading in the event that we need be, but we don't foresee that happening.
Okay, just put it in the order then.
And I'm fine with that. Your Honor, your staff has been excellent to work with. I don't know if we'll have an opportunity to say goodbye to you, but it's been very nice.
That's because we beat them regularly. So that's
whether they deserve it or not. That's how I keep my kids in line too. That's what you got to do.
Exactly. Okay, gentlemen, thank you, and get that into us, and we'll get it signed and put in the file, and then wait to hear from you.
All right, thank you, Your Honor.
Peter, I'll call you.
All right, Seth, thanks.
All right, very good. Let's move on.
How do you beat them, Judge? What do you use?
Hi, Judge.
Hello.
Hello.
Hello. My client is logging in as well, but if we need to start without her, we can because we have consent. So whatever
You
this
deal with it
better
then?
for the court.
Okay, all righty then, yeah, because she hasn't, I don't see her here yet. Okay, this is case 2022-3374, DM Lewis Adams versus Brittany Adams. It is Monday, June 5th, 2023 at 1:33 p.m. Attorney Kelly Podolsky for plaintiff and Attorney Anya Henderson for defendant.
Mr. Adams, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in, then we'll proceed.
Sir, do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I swear.
Okay, Ms. Podolsky, you can proceed when you're ready.
Thank you. Mr. Adams, will you please state your name for the record and spell your last name?
Lewis Robert Adams, Adams.
Thank you. And do you recall coming to my office and signing a complaint for divorce?
Yes,
And in that complaint, you stated you'd been a resident of the state of Michigan for at least 180 days and a resident of Calhoun County for at least 10 days. Was that true?
yes,
And in your complaint, you stated there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood your marriage could be preserved. Was that true when you signed the complaint?
yes,
Does that remain true today?
fortunately, yes,
Is it correct that you participated in mediation in this matter and settled all issues?
yes,
And is it correct that that agreement after mediation was recorded?
yes,
And is it correct that neither you nor your wife are seeking spousal support?
yes,
And do you understand that neither you nor she can come back to the court and ask for spousal support in the future?
yes,
And you and your wife have 2 minor children together, is that correct?
yes,
And the issues of custody and parenting time were settled, is that correct?
yes,
To your knowledge, is she pregnant at this time?
no,
If when it is received by the court, for some reason the judge does not sign the judgment of divorce, do you believe there's any chance at reconciliation with your wife?
I would like to.
Oh, drama.
but I don't know. So I've always been the one working to fix it. So
Oh dear, buddy, this is not
I don't,
therapy.
I can't give you a yes or no. If she were to ever want to reconcile, I more than likely would try again.
Okay, but at this time, when the judgment of divorce is completed, you will be signing that. Is that correct?
Yes.
Okay, thank you. May it please the court.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the paperwork. You're not divorced until I actually sign all of that paperwork. It still may take a couple weeks, so best of luck to you. I hope everything works out for you, and the court will conclude this matter at 1:37 p.m. You're free to go. Have a good day.
Thank you.
Ooh,
Thank
what
you.
was that face she just
Okay.
made?
So stay here, Kelly. I want to see if I can get the King Short for you.
Okay,
Let me see.
I'm surprised. I've seen a judge toss a marriage or a
Shallon
divorce
is
case like
there.
that before.
is,
Attorneys Savage. I'm not sure if.
do you see Antoinette there?
With the timestamp in the chat or something, God rides a Harley. We have to figure
No.
out a good way to do this.
Unless, let me see, I don't know who this is, hold on.
That's her.
It is? Okay, so let's wait while we connect to the other one.
I always feel sorry for the sad people that don't want to be broken up with, but they often
Please
become
unmute, ma'am.
stalkers.
Antoinette King Short, correct?
Yes, sir.
Okay. So I have my own chat.
Oh.
Okay, this is case 2022-1737 DM Shallon King Short versus Antoinette King Short. It is Monday, June 5th, 2023 at 1:38 p.m. Attorney Kelly Podolsky for plaintiff and attorney Kimberly Savage for defendant.
Good afternoon to
Are these lesbians? I guess it's so funny. I'm such a child. To be clear, I love lesbians. I love all people, really.
all of you.
Judge.
My understanding that based upon what we've received information, you have settled the matter. Is that correct, Ms. Podolsky?
Well, we had, and then I received information on Friday that defendant would not be willing to sign the judgment of divorce. She wanted to renegotiate some of the terms for mediation. And then I am aware and received a motion to withdraw as counsel from Ms. Savage. So at this time, I think I would let Ms. Savage provide any input she has.
Okay, Ms. Savage, what's your input?
Your Honor, I may not have much more than that to offer. There's a communication issue with my client, very clearly. And it is true that we mediated and we resolved matters of property division. And then the next day, plaintiff's counsel, at least in my opinion, offered us everything we were looking for in terms of custody, parenting time, and support. And then my client did ask me to go back to Ms. Podolsky and ask her to renegotiate one of the terms of payment. Ms. Podolsky's client refused to do that. And then it's my understanding that there was a text message that went back and forth asking for additional changes. And as to the content of those changes, Your Honor, I have no information.
Okay. Well, was the settlement conference, was that recorded then when you had a settlement?
Unfortunately, no, it's my understanding by the time we reached a settlement, the minor children were present with the defendant, and it was not appropriate to place that agreement on the record at that time due to their presence.
Okay. Well, Ms. Podolsky, what are you suggesting at this point?
Well, it's my understanding from communication with court staff this morning that the motion to withdraw as counsel is going to be noticed up here in a couple of weeks. I am certainly happy to speak with Ms. Savage to see if we can preserve what arrangements or the agreements that we have reached. If we can't, I would state that the defendant is in default and we may just notice up a default judgment of divorce.
Okay. Well, you can do what you wish to do. So take care of it. And then what we'll do is just address stuff at the time on the motion to withdraw and see where we're at that time.
Okay.
Okay.
Thank you.
Thank you. And court will end this matter at 1:41 p.m. You're free to go. Have a good afternoon.
You too.
Thank you.
Okay, very good. Let's move on.
Whoa, I barely skipped and it looks like we went back in time. Who is this gentleman coming from the 70s at this table?
Hi.
Mr. Sorry. Can you hear me, Mike? Yes.
Yeah, now I can. I'm gonna go bring Mr. Kinney in. I had a different lineup, so I'll be right back. It'll be 30 seconds.
Okay.
That lady sees that blue jacket. She's like, damn, I better take off my blouse. Can I undo a button here? Do you see that man wearing that powder blue suit, sitting at that power conference table with beige seats?
Yep.
Look at how shiny
It'll just
that
be a
table
minute.
is.
Oh, this is the mediation.
Is this a divorce case again? That's a divorce attorney? Of course it is. What
I'm already
is
on there.
this?
Okay.
So I don't have to.
Okay, so this is case 2022-3230 DM, Vicky Kinney versus John Kinney. It is Monday, June 5th, 2023 at 1:44 p.m. Attorney Serafina Cochran for plaintiff and attorney Michael Toth for defendant.
Okay. Good afternoon to all of you. Ms. Cochran, as you represent the plaintiff, I do have a mediation report says that you're going back to mediation on the 23rd. Is that correct?
I'm sorry, my note just here says the 25th, so I'm sorry, the 24th, so it's
Yeah.
either going to be the 23rd or the 24th.
Yeah, confirm it with Mr. Brundage. The form says the 23rd, so.
The 24th is Saturday.
Well,
If that
definitely
makes
not
any
do the
difference.
24th then.
Maybe Ms. Conference going to decide to come in on the weekend then.
Well.
Never.
No.
So, okay, correct. It is June 23rd at 9
Yes.
a.m.
Okay.
I am so sorry. My note was that May 24th was the first mediation.
Okay.
That is where the confusion is.
Okay.
So the 24th was right.
Okay.
Okay.
What we'll do is let you go to that and complete that. We'll set another settlement conference approximately a week or so after that, and we'll get you in and see where we're at that point.
Very good.
Okay?
Thank you.
Okay, thank you.
Very good then.
Yeah, give them maybe a couple.
Mike, would you be available for a call if I give you a call?
I've got a couple more of these. I'm going to be going over that proposed order with Mr. Kinney when we're done. He's here. He's going to stay here.
Wonderful. Thank you. Bye-bye.
Thank you.
Okay, thank you.
All right, so your other case is, you should have stayed. I believe I have those people. Okay. I'm gonna go to his other case.
He's got two. He's got, okay.
Gaines Thompson.
Okay.
And Oh, wait, maybe he's going to, okay. Maybe he's going to rejoin the C drive. Okay. My apologies. I did have Attorney Toth, but it's probably going to reconnect. We will bring you guys in just a moment, okay?
Thank you.
All right.
Well, I'm lost on the other one with Todd too.
Everybody favorites.
Just get Mr. Todd in and his client.
Okay, I'll get Todd and Love for a favorite. Let me see if there's. I don't think I have everybody for that one. Wes, do we have Dominic favorite? I don't see him. Is he in your office?
Not in my office. I'll give him a call.
Okay, so he's not there. Okay, we'll get back to you on that one. So, okay, my apologies.
No, you're great. Thank you.
And I do have Mr. Toth for, let's go back to the Gaines v. Thompson. Wait a second. Gaines is not connected to the audio. Wait, okay, there we go. Everybody please unmute. Can you hear us?
Yes.
Yes.
Okay, all right. This is case 2023-400 DC. Doris Gaines versus Grace Thompson. It is Monday, June 5th, 2023 at 1:48 p.m. Attorney Paul Omla for plaintiff and Attorney Michael Toth for defendant.
Good afternoon to everyone. We'll go to you first, Mr. Umlauf. Tell us what's happening in the case.
Your Honor, we have a temporary agreement as it relates to the issues of custody and parenting time. Mr. Toth and I have been discussing child support, and I'm awaiting an updated proposed uniform child support order from him. The nuance, I guess, that we're dealing with on this one is that because my client has spent a prolonged period of time without seeing the minor child, or at least as her father, the agreement is that we would have a reunification counseling and supervised parenting time for a period of 90 days and then revisit it and then revisit those issues to see how things are going after those 90 days. In speaking with Mr. Toth, I think that might be an appropriate time to do mediation with Lisa at that point. Mr. Toth, did I get all that right?
Yes, yeah, Judge, I would agree with everything that Mr. Umlauf has related. We have an 8-year-old child, and the temporary order includes reunification counseling, supervised parenting time, some other counseling, and in all honesty, until we can initiate that process and see how things go, it was pretty much agreed between counsel that we're not going to be able to finalize anything. So we talked to Ms. McNiff, and she agreed to come in and mediate at that time. And I would agree with Mr. Umlauf's representation regarding child support. We're just rerunning another calculation, and we'll forward that over to him, and he should have that in the next day or two.
Okay, well, we're 115 days in, so I don't want to extend this out more than necessary. So I guess I'm concerned about what's happened in that 115 days as to now we're saying, okay, we need 90 more days, and then we're talking about mediation. I'm not going to extend this out that long, so.
Your Honor, I do understand that. I think part of the issue is it over the past 2 months, what we've done is negotiated to get where we are right now. We have Maridessa cats to get lined up, and we have some other counseling to set up.
That's fine, but why haven't we done it instead of saying we're going to be doing counseling? You know that that's something that you wanted. Why hasn't it been done
Yeah.
yet?
Your Honor, I with what the way we've narrowed the issues here, I guess I would have no objection if the court simply said, if the court is so inclined to set it for a hearing date, that gives us at least a period of time to get these things initiated and evaluated at that time, and maybe sneak in a mediation sooner.
Okay. Why don't you guys, I'll have it set, we'll set it for trial approximately 90 days. And what happens is we either have something at that point as far as resolution, or we're going to go to trial.
Very good.
Okay. Thank you. We'll end at 1:52 p.m. You're free to go. Have a good afternoon.
Thank you.
Thank you, Your Honor.
Okay.
Thank you.
Thank you.
Okay, Judge, we're done with you right now. We're going down to Florida.
Taking so long, Fambro?
Why are you here? What happened? Why are you early?
Let's start off with you're welcome. You're welcome. You're welcome. No, not just Fambro.
Why are you early?
You got me for the whole week. So
Just had it. Are you shitting me?
surprise, surprise, surprise.
Right here. What? Oh my gosh. Yeah, we're
Hey,
going
Ms.
there.
Laurel, I understand you've been given copies of paperwork and advised of your rights. Would you like to tell me?
Yeah.
Ms. Laurel? Would you like to tell me? On behalf of Ms. Laurel? All right, Ms. Laurel.
We're going back to the start because I like this guy. Hi, Courtney. Take care, Prissy.
Taking so long, Fambro?
Why are you here? What happened? Why are you early?
Let's start off with you're welcome. You're welcome. You're welcome. No, not just Fambro.
Why are you early?
You got me for the whole week. Surprise, surprise, surprise.
You told me about that.
It's a bonus week. It's a bonus week. Pure bonus week. Ms. Laura, you're fully court charged of domestic violence, battery, and resisting officer without violence. You understand those charges, ma'am?
You understand what you're charged with?
All right, Ms. Laurel, I understand you've been given copies of paperwork and advised of your rights. Dana, you here on behalf of Ms. Laurel? Would you like to tell me?
Yeah, what I wanted to let you know, Judge, we have, before you, Ainsley Laurel, for parents.